We also see women continuing to pioneer the welfare state during this time period. Protective legislation was something progressives usually applauded, reformers were working towards, and something that equal rights feminists, for example, people like Alice Paul, who will go on to establish the Women's Equality Party, opposed it. Protective legislation just essentially meant that there would be special laws for women and children because they were, thought of as biologically inferior to men and therefore in need of laws to help them. So in 1908, Oregon had a law that essentially limited the the time that women could work. Right, they set a 40-hour work week, an 8-hour day for women, and this ends up going up to the Supreme Court because a few years prior, New York had a law limiting the hours bakers could work, right? Saying that 40 hours was the maximum bakers in New York could work. And this case went up to the Supreme Court in the case of Lochner versus New York, invalidated, the Supreme Court justices invalidated this New York law that restricted the weekly working hours of bakers. And they restricted it because, or they rescinded this law, saying it was unconstitutional because this is thought to restrict people's freedom, right? Their freedom to contract, their freedom to decide how much they work or how little they work, right? That was sort of a violation of kind of this newfound freedom after slavery is abolished, that no one, no government, no agency can tell you how long you can work. And so this is sort of the era of Lochner, where people really are working absorbent, hours because they know that if they don't, someone else will. It's sort of like a dog eat dog world. Like you have to, if you want to work, you are going to have to do those hours or you're going to get fired, right? There's no protection. There's no government, stepping in and saying that this is the maximum hours people can work. And unions, some unions were strong, but the government in this case of Lochner versus New York said it's unconstitutional to limit somebody's hours. So in 1908, when Mueller versus Oregon, when this Oregon law goes to the Supreme Court upheld the law. They sort of contrasted themselves with the Lochner case because they justified sex discrimination in labor laws. And it was really in the government's interest, from their point of view, in public welfare, that the law outweigh this freedom of contract precedent that had been set by Lochner versus New York. Justice Brewer was the one to write the opinion of the court that upheld the Oregon regulation. And we really get insight into sort of his and the other justices' childbearing physiology and the social role of women, provided a strong state interest to reduce their working hours. His quote his opinion to the court is, quote, "The woman's physical structure and the performance of maternal functions place her at a disadvantage in the struggle for subsistence is obvious. This is especially true when the burdens of motherhood are upon her. Even when they are not, by abundant testimony of the medical fraternity continuance for a long time on her feet at work, repeating this from day to day, tends to injurious effects upon the body. And as healthy mothers are essential to the vigorous offspring, the physical well-being of woman becomes an object of public interest and care in order to preserve the strength and vigor of the race." End quote. So this is 3 years after the Lochner case, and in it they're saying that it's in the interest of the government in the state to protect women, to limit their number of hours because they are mothers, and If they are on their feet too much, potentially that could be bad for their fertility or something like that. I don't really understand. But what it did was gave women an 8-hour day. And this was seen by the maternal feminists as a win. The reformers, this was a win for women like Alice Paula, as I said, who were trying to get equality to men. This was seen as a disadvantage because the court is seeing women and men as different and therefore not equal to the same rights. So reform, women are really bringing their maternalism to social issues. Historian Nancy Cott argues that there are 3 things that informed women's activism. One was their maternalism, right? This idea that they have kind of a biological maternalistic, thing inside them that leads them to want to be protective of the vulnerable, of children, of people who are disadvantaged, right? The second is this interest in feminism. And feminism, as she describes it, is combating gender hierarchy, right? They're involved in public activism to try to increase women's rights. And the third thing was to improve their own community. And I think we can see this especially when we're looking at the National Association of Colored Women, which was a self-help organization that Booker T. Washington, the prominent civil rights organizer, endorsed. And it adopted the motto, quote, "lifting as we climb," end quote, to demonstrate to, quote, "an ignorant and suspicious world that our aims and interests are identical with those of all good aspiring women," end quote. So for African American women especially, reform was about combating racism and trying to uplift their community so that they could have the same educational, economic, work rights, and opportunities as white people. Again, the settlement house is sort of an example of that. Whole House, which Jane Addams and Ellen Gates Starr started, was really giving the state, the government, society in general, a sort of vision for what the welfare state would look like, right? And these women are helping to envision an active government in protecting and aiding those who are impoverished, right? They are pioneering a view of a more liberal government that is going to regulate the economy, that's going to regulate the workplace for the workers, and they're going to intervene and help improve conditions for the poor people. They're not going to allow the kind of squalor to be as rampant as it was in the US at this time. And one more image of Hull House in Chicago.